Our next speaker is Breen Stevens. Some of y'all may remember Breen from the PD conference last fall, where he was the president of the PD Association for the past few years and running that. Breen's also been appellate defender, private attorney, appellate defender, and he's going to talk to you this morning about pretrial release.
Is it still? Yeah, good morning, everybody. How y'all doing? Can you hear me? I mean, is it too loud or no? I'm told my voice carries. If it's too loud, I can take it off. It's not a problem, okay? Well, all right. I hope everybody's in here having a good time, right? We got the holidays coming up, right? Okay. Everybody looking forward to getting home for the holidays, right? Yes. All right, good. Because we're here to talk about doing what we need to do as attorneys for our people, our clients, so they too can get home for the holidays too. Every human being we represent has a family. I don't care if they are just in there stuck because they're traveling through. I don't care if there's somebody that has a habit. I don't care if there's someone that's actually down in luck in life itself. They still have families. We need to get them home. Okay? Because let's be real. When someone's charged with a crime, they're not convicted of anything. And literally, our laws flat out say bond cannot be used as a form of punishment. All right? And yes, this is not just us saying this. This goes back a long time ago. Even in our own jurisprudence in 1895, if it suffices to accuse, what will become of the innocent? And remember, each and every single person of our clientele that's sitting in those jails is presumed innocent. Now, what else? Let's get to it, okay? When we're looking at it, when we have to ask ourselves, when we have a bond hearing, okay, it literally starts where? Within 24 hours of arrest, right? They have to be brought in front of a judge who's got to be fair and impartial for arraignment. Now, I understand most of you will not have been appointed at that time, but you're still going to need to know everything about it because you will use this exact same information and factors when it does get to General Sessions Court. Others of you might be working in municipal court or magistrate's court, so you're going to need to know this then anyway, okay? So stay with me, because you got to know your audience. It's like the same thing when it comes to sales, right? Number one, know your product. Number two, know your audience. In this instance, your audience is the judge, only the judge, not the jury, okay? Keep that in mind. What are our two touchstones, main touchstones, for bond? The Constitution. Yes, the federal Constitution. We love the federal Constitution. It's a great thing. However, it's the floor, right? That makes it so excessive bail cannot be required as a condition for bond. Excessive bail. Well, in the eyes of whom? Well, I don't know. My view, it's in the eyes of my client and their families, right? Nor excessive fines imposed or cruel and unusual punishments. However, we actually have Article 1, Section 15 of the South Carolina Constitution, which is actually far more protective of our citizens here in South Carolina. All right? All persons, not one, not two, not Bob, not just, Sally or, Olivia. No, all persons shall be, before conviction, bailable by sufficient sureties. Okay. But can be denied to certain folks charged with certain things, like if the penalty is possibly death or life without parole, or if it's listed under 16-1-60 of the South Carolina Code, if it's a violent offense or crime of violence, then they're allowed to deny bond. But I don't know about you, I'm still asking for it, right? I want it set and I want it to be reasonable. Why? Because they still can, okay? They got to give due weight to the evidence, nature of the circumstances of the event. We're going to talk about that too. And again, a similar provision, excessive bail shall not be required. Oh, $1 million bond, Mr. Stevens. Whoa, judge, objection, that's unreasonable, right? Be comfortable saying that because it is. Right? How many of our clientele, especially as public defenders, can afford a $500,000 bond, $1 million bond? Nobody. Are you kidding me? By definition, they're broke. We work for them, right? Okay. So what does it really mean? All persons, because this actually gets down to the statutory section. Yes, we have a statutory code that starts in Title 17, then you're going to go into Section 15, and then subsection 10 is where it really starts, and it's going to go on from there. You're going to want to know these, where they're at, and know these factors, because this is where we make our bread and butter in arguing before the court for bonds to be set for our clients. All right? Again, all persons are entitled to a what? A PR bond, for God's sake, right? Why aren't we demanding this? Judges say, yeah, I know, Mr. Stevens. They'll try and pawn it off. The answer is, Judge, it's not me just saying this. This is the General Assembly who writes the law for South Carolina. We're asking this court to actually enforce the law as written by the General Assembly. They get uncomfortable when you say that because you're right, okay? So yeah, the default is what? PR. Okay. Without a surety. Who the hell wants to have a bondsman? That means you got to pay a fee to a guy. You're never getting that money back, right? In any amount of charges. Unless, yes, there's always an unless, right? The PR bond will not reasonably assure their attendance at the court and or the person is an unreasonable danger to the community. True story. I was in General Sessions Court when I was actually asking the judge to reconsider the bond that was actually denied before, right? And I used the exact words, Judge, he doesn't represent a flight risk whatsoever, for all the factors we're going to get into later on, and he does not represent an unreasonable danger to the community. He looked up at me kind of smirking, Mr. Stevens, you keep on saying unreasonable danger. So, I mean, really? It doesn't, he's just a danger? It's like, well, actually, Judge, that's the language provided to us by the General Assembly of South Carolina. I take it they mean what they said in their plain and unambiguous language. So yes, that is a standard for this court to apply. We ask the court to apply that standard. You get their attention quickly. Again, like Bob said, be polite, right? There's no need to be rude or nasty in court. We took an oath of civility for good reason, but just because we're polite doesn't mean we don't have a spine. Public defenders are the best attorneys you're going to find on earth. They got hearts of gold and spines of steel. We're the ones who actually stand there in between courts, judges, and prosecutors, in between them and our clients. You got to be the one to stand up for there and actually say what some people don't want to hear, including these things, right? So, like I said, the two main prongs. Are they risk of flight? Do they represent an unreasonable danger to the community? All right? Now, when they actually do set a bond, oftentimes there are going to be additional conditions on there, and that's actually quite reasonable, right? Do I really want two people who've been fighting like cats and dogs, and my client's the one who catches the charge, not the other person? Do I really want them to be hanging out in the same house again right afterwards? Probably not, right? Frankly, it's for the betterment of my client's situation that he's not around in that spot, right? Or it's like I tell my kids sometimes, no, I'm not going to put you in the same room with the cookie jar because I know there's not going to be cookies left in that jar later on. You got it? So what should they consider? What is the amount necessary to guarantee their appearance? Real question. That's what is reasonable, right? Why we actually associate money with a guarantee they're going to show up is beyond me. That's something we're still trying to figure out in American jurisprudence today, right, when it comes to cash bonds or sureties, right? Is supervision necessary? That's the surety part. So if they say cash or surety, hey, I want the cash side because the surety means they got to pay a bondsman, right? Restrictions on travel or association of residence, that's kind of reasonable as well, right? Think these things through before you set foot in front of the judge. This isn't just something that you just go up there all pell-mell, oh, hey, by the way, Judge, I think this is reasonable. No, know this stuff before you get in there for your hearing. Just like anything else in our profession, most of our work is done out of court. When we get in court, boom, you get up there and you put forth the fruits of your labor, okay? And again, any other necessary conditions. The big favorite thing going on these days is that Martha Stewart ankle bracelet. I hate them. I mean, I genuinely hate them, all right? Why? Certain counties like Richland, they have like this centralized thing, and it doesn't cost some money, but let's be real. Do they always work? No. And they're just thorn in the flesh of our clients, all right? And frankly, they're putting them on cases where they really have no business being on there. You're like, wait a second, this guy's clearly not a flight risk. He's a pillar in the community. This charge is like some sort of white-collar crime nonsense. And you're telling me like, oh, we got to watch him. Well, he has no passport. He has no Swiss bank account. He's rooted in the community. He's grown up here his whole life. Why do we really think he's going to run anywhere? He's not, right? It's not a crime of violence. It's not like he's looking to turn around and accuse of beating the crap out of his spouse. There's no provisions where he has to give any space around somebody else. Why are we even having this ankle monitor on? Well, there's a contract, you see, between the government of Richland County and these other things, and they just basically want everybody on him, right? Fight it. It's an unreasonable condition. If you think it's unreasonable, stand up. You're the one there to stand up and say so, all right? Just because judges have it on a form doesn't mean that every single box has to be checked. They're the ones who actually are supposed to have and exercise their discretion on what is necessary and right. Ask them to exercise that discretion. Literally remind the judge that he is empowered to do what is right and necessary given the individual conditions for your client's case, okay? Now, yes, sometimes, believe it or not, they have some crazy restrictions. No, you can't go in this entire county. Wait, what? No, you can't go past this county line in the state of South Carolina. You're like, whoo, time out, all right? Make sure the conditions are reasonable, okay? How high is enough? Again, it's got to be there to calculate it to assure that they will show up and protect the community so he's not going to do anything stupid while he's out, right, or she. However, if it is a magistrate or municipal offense, guess what? They can't set it higher than whatever the fine is. Yay. All right, I like that. And yet, once it's set, it can only be reconsidered before it's transmitted to the General Sessions Court. So you've got a real short window of time if you're going to try and get it back in front of the magistrate judge or municipal judge, okay? Now, Alternatives to surety bonds. I like this, know this, be comfortable with this. Why? Because this is better for your clients, okay? Why? If there's a cash amount that they're allowed to put, in other words, they say cash or surety, hallelujah, right? They might have some family, they might have some friends, whatever it is, but they can take whatever that bond amount is in cash and put it up with the court. Why is that important? Because they get that money back at the end of the case. More importantly, once that money is put up, it is freely transferable. Meaning what? You can double dip on that. This is really important for clients that actually might be considering hiring a private attorney. Why? If they say, oh, it's a $25,000 bond. If they're able to turn around and actually find $25K, holy crap, right? More importantly, there's another provision under 17-15, I think that's 15? Yes, -15, where you can ask for a 10% cash in lieu of bond provision. That's gold. Why? Because if they say, oh, it's a $25,000 bond, or even a $50,000 bond, and they allow that provision that they can take 10% of whatever that bond is, put that amount with the court, and the person can bond out. Again, more importantly, they can use that same money that's there with the court and it's freely transferable. So if they choose to go hire a private attorney, then they can use that same money there, assign it over, so when the case is done, that goes over to whoever that attorney is, right? Ask for that because it helps the clients out, it helps the families out because they can get that money back rather than having to pay a fee to a bondsman they will never see again, okay? Assuming that it's a cash or surety. Now, factors. We need to know our factors, and we need to know them well, right? Nature and circumstances of the offense. I always have to tell this to the judge because why? The judge is going to have a copy of the incident report, at least it's supposed to at initial bond hearing. And even if it's not initial bond hearing, when we're going to get to later on for bond reconsideration, guess what? The prosecutor is going to stand there and call your client everything but a dirty shovel. All right? He's going to read through that incident report. Oh, he did this, he did that. Oh my God, Judge, you should hear about his record. Did you know he jaywalked in 1983? Right? Believe me, they're going to say everything, right? You should deny it. Okay. First thing you say, Judge, we're not here to argue the facts of the case. As you know, this is merely a bond hearing. However, I know you need to know the nature and circumstances of the offense. So let's talk about that. Push back on the prosecution, for God's sake. Don't let him just get away with actually saying, oh, smear your client. It's like, no, Judge, let's do this. Let's say, for example, if your guy was actually just out there driving his cousin, dropped him off at the campus, he said, oh, I need to stop off here to make a withdrawal at the bank real quick. He doesn't know his cousin's a bank robber, for God's sake. Guy goes in there, does some dirt, comes on out. Hey, here's $10 for your gas. Thanks for dropping me off. Your client's charged with what? Well, hand of one, hand of all, bank robber. God damn it, right? Is he a really bad? Is he going out there with a Charlie Manson tattoo and a dirty, hairy handgun, robbing every place along I-95? God, no, he's not, right? Let the judge know that. Judge, if we're talking about what's going on here, we got an actual innocence claim. My client didn't know one thing about what's going on here. He's not a danger to the community. If anything, he's merely present. And frankly, the government's own evidence will show that. They want to say all these things. They're saying what someone else did. He had no knowledge about it whatsoever. And if you watch these videos, I presume when we actually get them, assuming they'll eventually turn over the evidence to us, because by the time this happens, they're usually playing that game with you, right, when it comes to discovery. Let the judge know they're screwing around, they're withholding evidence from you there. Use the time. Use it wisely. It's your chance to get in front of the judge to push on it, okay? Judge, they're saying all these things. Obviously, they got these files here. Where is it? We still haven't even seen all this stuff. However, from what I do know from our own independent investigation of the facts, no. Push back. If you got an alibi defense, let the judge know. Judge, as far as I know, right now, he wasn't even there at the time. Judges will go, wait a second. They're not going to stop everything, but at least give them pause. Pause to think and reflect. You know, we need to be reasonable about this. Yes, yes we do. Know the nature and circumstances, not only the offense, but also your client's situation. Okay? Like I said, you're not here to argue the case. You're not here to argue in front of a jury, but be prepared to at least push back with something to the judge to say, look, he's not this monster the government's making him out to be. All right? Ties to the community. Love the ties to the community, right? Most of our clients, most if not all, probably grew up in the community where they've actually been arrested, right? Okay, use that. That's a bonus for you. It shows he's less of a flight risk. Hey, he grew up here. He went to school here. He's still working here at the lumber mill, for God's sake, right? It goes to employment as well. Yes, he's employed locally, or he's around here. Fine. Financial resources. Most of my clients, you know, we say don't have a pot to piss in or a window to throw it out. All right, it's true. They're broke, right? He's not a flight risk. He doesn't have a passport, doesn't have a Swiss bank account, doesn't have any, you know, securities or bonds or anything like that. Let the judge know, okay? He's not Bernie Madoff, for God's sake. What about his character and mental condition? Be ready to talk about that too, because why? Especially when it comes to mental condition and, by the way, physical condition. Ask yourself, if he's held on bond, Who, under the 8th Amendment, is required to care for that individual while he's actually in jail? The government. All right? Almost a decade ago, when I first looked into it in Orangeburg County, it was costing $40 a day per person in the jail for 3 hots and a cot. That's if they had 0 problems. If they had more, it costs a heck of a lot more. What if he's got heart issues? What if he's diabetic? What if? That's cost that has to be borne by the county. Be prepared to push that to the judge. Judge, he's got a heart condition, he's got 25 stents in his body, no joke, right? Not only he's got neuropathy in both of his feet, and frankly, I don't think this jail is even equipped to handle any of that stuff, right? Unless they actually want to have a regular visit to the doctor's office at least twice a week, because that's what he's doing right now on his own, and when he's in jail, I can guarantee you the food they're going to be shoving in his face and how they're going to be treating him there is going to be far worse. He's going to have to go to the hospital again on the government's dime a lot more often. Tell him, right? Don't hide from it, push it. But in order to do that, you got to know your client, right? Know your product. Prior record, know that, be ready for it, all right? It's coming, right? And whether he's an alien, right? And I don't mean like Pluto or Mars, I mean like, yeah, if he's south of the border or north of the border for that matter, right? Okay. Victims and victims advocates, all right? Article 1, Section 24 of the South Carolina Constitution is there and it's real, okay? We have a Victims' Bill of Rights in South Carolina under our own Constitution, okay? Go through it, know it. It doesn't say that they get to derail everything. It doesn't say that they actually get to have their way for every single thing that happens. It says they have the right to be present and they have the right to be heard. Okay, gotcha, right? What else? There's statutory language as well, following and filling in the gaps. What I want you to notice, though, when you read 16-3-1525, excuse me, there it is. They're entitled to what? A reasonable notice. All right? Make sure you have that in your back pocket. All right? I don't know about you, anytime I get ready to go to bond hearing, I got like several documents and statutes always already printed off. It's like a mini file, boom, it's going with me every time. Have it. Because if you get a visiting judge, you might have to walk it on up. Right? Why? Oh, where's the victim? Oh, we can't go forward without the victim. Whoa, judge, yes we can. It's not just the victim who has victim's rights. My client has the right to have his bond heard within 24 hours of arrest at arraignment. Not only that, if I'm actually there for what we're going to talk about again later on, the government's had plenty of time well in advance to send out notification of this bond hearing and bond reconsideration. If they fail to do that, that's their problem. We have a constitutional right to have this. We also have a statutory right to have this. Right? And by the way, my client's rights under the 8th Amendment and Article 1, Section 15, my argument, it trumps theirs. They're not entitled to absolute right to be here and to be heard. They're entitled to a reasonable notice, period. Okay? Push back. Be ready to push back on that one. Again, politely, professionally, but you got to have spines of steel. Okay? Now, again, it's got to be reasonable. They got to give sufficient notice, everything like that. Why? The bonds are probably going to contemplate protection for the victims. We already know that that goes under what we spoke about when it comes to no certain restrictions that are going to likely be part of it. And frankly, when it's your turn to speak, be prepared to push that forward. Judge, we're fine with the no contact provision. In fact, I think that's probably better for everybody involved. You come off as the most reasonable person in the room when you're talking things like that, right? Sometimes I might say, even if I'm just looking for a number on a homicide case or whatever, Judge, we need a number, right? We're fine. And frankly, we're fine if there's, a GPS monitor, no contact provision with the victims. I think it's entirely reasonable, Judge. That's fine. We don't even want to be around each other. They're fine with this. Just give us a number, right? And be prepared with the number to throw out there, okay? Now, again, like we said, even though you're not appointed, why do you got to care? Well, because you're going to have to argue the same things when it comes to reconsideration, which we're going to get to in just a sec here. Again, 2 main rules. Number 1, know your client and your case, right? 2, know your audience, the judge, all right? I mean this not in the sense of like, oh, he's just bad at this, or oh, she's just bad. No, know your judges because they're human just like everyone else, all right? Certain judges have certain touchy points that they're sensitive to. Others have, more proclivities to go different ways. Know your judge, know your audience, all right? Some might be really, really averse to, say, domestic violence type cases. Okay, be prepared for that and be prepared for what you're going to argue, all right? Sometimes people might say, oh, they just hate everybody who's charged with this type of crime. It's like, hold up, did you dig deeper? No, there might be a situation where if it's total violence, yeah, I got it, but at the same time, if you actually show, again, knowing your case, Judge, it's not what the government's making it out to be. The person who actually initiated this was the other spouse, This person was literally just trying to back the person off and defend themselves. This person came at him with a giant wooden pole. What did you expect them to do? Just take one to the head and get dropped? No. Snatched out of their hands, pushed them back. That's where this came from. Be prepared, okay? But like I said, you got to know your client. You got to know your judge. And when I say that, I mean know all of this before you set foot in court. Most of your work in this profession is done outside of court. So when you step foot inside that courtroom, it's game on, okay? Now, reconsideration. This is what's going to touch on most of you here. Okay, why? This is where it comes to General Sessions Court. What happens if it's either A, denied by the summary court, or B, they just set it so far above and high that it's just totally unreasonable, right? Yeah, you file a motion. You file a motion pursuant to 17-15-55A1, love it, okay? They can review it in circuit court, okay? And again, they're going to go through the different factors and be prepared. Be prepared to argue 8th Amendment. Be prepared to argue Article 1, Section 15, like we said, as well as the factors previously listed. You got to know it. This is where the chips are really down. They're down and they count. One of the other things I like to do when it comes to these things, look, in advance, determine where they're going to stay, who's going to be with them, who lives in that house. Is the guy charged with possession of kiddie porn, and yet, oh, by the way, he's going to stay with his mom, who has 5 other kids there too, and she runs a daycare center. Hell no, no judge on planet Earth would go for that, and rightfully so, okay? Be reasonable, have things mapped out, I mean it, okay? So, plan it out. By the way, are there firearms in that location? Ammunition? I don't know, is he going to have a job? Here's what we like to do. Get things done. Just because I can file this right now, no. Be smart. Talk to family. First, get your client's consent. Talk to your family members. Talk to whoever the bosses are. If they can't make it for the hearing itself in General Sessions Court, get an affidavit. Mr. Smith will be working with me. He's a fantastic worker here at the lumber mill. He can work, 9 to 5, whatever. We can work around the schedule. That's fine. If there's an ankle bracelet, so what? Be ready to say, Judge, we're ready for conditions like, a curfew. Okay, so what? Let's do it. All right? Have it ready. I'll explain to you why. Let's back it up. No, this is good. Because if you miss, in other words, when you're there for your motion to reconsider, first time up, that's your golden shot. Why? If you don't get it, you have to wait for what's called a material change of circumstances. And that really sucks. All right? That could be in the facts. That could be through an investigation of matters. That could be from the government turning over something to you going, what? Hey, look at this. This is fantastic. Let's get in front of the judge. Other times that you're probably not going to want to announce on the record, but you're going to talk with the prosecutor, maybe the judge in chambers beforehand. Hey, my client is the key witness in this case, and he's working with the government. That, to me, is a material change of circumstances, don't you think? Yeah, but I'm not going to put it on the record in front of everybody else who's sitting on the bench that might actually stick something in my client that we don't want there, right? Talk it out, work it out, be prepared to argue it, right? Why? It's either that, you get a material change of circumstances, or you got to wait 6 months, which according to statute qualifies as a material change of circumstances. Even though some judges will say, well, Mr. Stevens, you say it's been 6 months, but what's the material change of circumstances? Well, Judge, according to statute of South Carolina law, given to us by the General Assembly in the plain and unambiguous language, that does satisfy the fact that it isn't it's unreasonable, and it's a material change of circumstances. We know it's unreasonable. Why? Because he sat for 6 months with a $350,000 bond. We know he's indigent. It's clearly unreasonable. This needs to be revisited now. Right? Be prepared to bring your arguments when it comes to it. Again, prepare out of court, so when you're in court, you got it. Okay? Now, when you do it, and you put your thing there for your motion in, you got to have the basis for it in writing, and you got to serve it. Why? Notice. Again, this goes to notice, and you're going to want to do this, because once you do put the government on notice, that's going to trigger their statutory duty to put somebody on notice. And oh, by the way, I don't know if you realize, but since 2013 it's supposed to be, the government doesn't control the docket anymore. Right? So, when it comes to scheduling our motions to revisit bond, the government and prosecutor are like, oh, well, we'll get to it, and they'll put you off. We all know this. Every circuit does things a little bit differently, even though we have a unified court system. It's not quite as unified when it comes to the systems. Okay, that's fine. Work within whatever system you have for your circuit. If they say you file your motion, you give your notice to the parties, and they said it, you follow it, all right? Other circuits where it's not quite as delineated, what I like to do, I'll notify the prosecutor, I'll serve them with a hard copy. Okay, great. And I'm also going to turn around and have a PDF copy, the scanned, and I'm going to email it to the judge. Judge, how you doing? This is Attorney Stevens. We have a matter that we need docketed for our next term of court. I believe it's a week and a half, 2 weeks, whatever it is. And then I also CC the prosecutor. By the way, the prosecutor's also been served with a hard copy of this. Attached is both the motion for this as well as our certificate of service to the prosecutor. What did I just do? I took it out of the prosecutor's hands to try and sit on it. Right? I'm being professional. I'm doing what I'm supposed to do. It's all above board. Okay? We got to do this. Got to do this. All right? Why? Also, but that notice, that puts the court on notice and the prosecutor on notice that the prosecution is supposed to be putting it out there to the victims so they have proper notice of whenever this gets scheduled. All right? So later on, I'm going to say, oh, well, Judge, the victims aren't here. They just didn't have time to. That's not my problem. That is not my problem. That's not my client's problem. They've had more than adequate time for notice. My client has a constitutional right to have this here as well as statutory right to have this here. And that trumps, especially because it's a federal constitutional right involved, our argument is always that it trumps. Okay? Now, revocation. Boo. Okay. So what happens if, say, your client's out on bond and something happens? Maybe he catches a new charge. Maybe he has a really not so nice run-in with police, right? More than just say, jaywalking ticket. Well, the government can turn around and make motions to revoke, just like we can make motions to reconsider. Okay? Now, again, they're going to have to file a motion. That motion has to have specifics regarding the matter they're concerned about. It has to be filed and served. Not just served upon you, but also served upon, wait for it, the bondsman. All right? Yeah. These are statutory requirements before this hearing can roll forward. Makes sense, right? Okay. If they actually have a prima facie showing, you got to have a hearing, a full hearing. I want that hearing because I want to hear and see what's going on here. We've had hearings like that before and beat the government back a lot of times. Why? Sometimes they're just totally overreaching. Well, this person said this, and the same person said this and this and this and this. Well, Judge, if I'm hearing correctly, first of all, we can have that person testify. Because right now it's just the prosecutor talking to you, which isn't evidence, and we got allegedly this person over here who we don't know anything about, don't know the background. It's hearsay within hearsay. This, what are we talking about? All right? For real. And some judges, they'll latch on it. They're like, yeah, you're right, Mr. Stevens. Other times they'll say, I don't care. Boom, off they go, right? Again, know your audience, know your client, know your case, okay? But you got to have the hearing. The other wonderful thing is this. The requirements, the statutory requirements are there and they're real, okay? Some judges will adhere to this. Others will say, well, I don't think there's any prejudice. We're going to go forward. To which my argument is, well, Judge, beg your pardon, we need a ruling on this because, frankly, that's an appellate standard, not the trials to court standard. We ask the court to apply the standard given to us by the General Assembly. Get a ruling on it, all right? Again, be respectful, be polite, be professional, but be firm, okay? And I've had judges say, yeah, you're right, stand down. And then the prosecutor, they get all in a huff and a tizzy, harumph, harumph, harumph. They go off, they jump another thing, they jam it in there, and here it is, and they'll file it and they'll serve it on me again and forget to serve somebody else, yes?
What did you say? You said get a ruling on what exactly? I just missed it.
Oh, perfect, yeah. So when we look at when the government tries to revoke your client's bond, there are statutory requirements. Not just, hey, here's a motion asking to revoke bond. All right, first of all, number one, it's got to be in writing. Number two, it has to establish the basis for which they're trying to say bond should be revoked. And number three, they have to serve you, they have to serve the bondsman. Those things aren't done. My argument is like, Judge, there's inadequate notice for any of this stuff. Why are we even having a hearing? Clearly, it's not even an emergency bond hearing. Yes?
Do they have to include exhibits? I've had one where they allege that text messages, like a violation with the victim.
Mm-hmm.
They said that text messages occurred, I guess, 2 different days, didn't provide me with the actual text messages.
Yeah. Again, that goes to the argument of saying, Judge, if this is supposed to be a full hearing like the statute requires, where is this evidence?
Well, that's what
Yeah,
I just put it on the record.
there is absolutely zero evidence whatsoever. It's just literally an officer of the court saying they heard this from another person, and we don't even know what they're talking about here. Right? Where are these alleged text messages? They have investigators. My God, it's the government, for God's sake. They've got more resources than God himself, if God needed resources, right? But there you have it, right? You're telling me that they're this unprepared to put this in front of you, Judge? No, this is a full evidence you're hearing. It's supposed to be our hearing. Where is it? Where's the witness on the stand? Where are these alleged text messages? You have nothing before you to consider, Judge. No evidence has been presented to this court. Accordingly, the government has failed to meet its burden, which is preponderance, okay? Be prepared to argue. They failed to meet their burden. It's an evidentiary burden. If there's no evidence put in the record, then they failed to meet it. Period, full stop. Okay? Okay. And again, if they are revoked, hey, later on, I want to know the bond hearing. Well, you can't, yeah, Article 1, Section 15, let's have it. Also see State versus Bill Right, okay? Now, what if the government misses? And you might have a solicitor that's out there that really, really has it out bad for your client. They just want him in jail. Why? Well, we know. Lots of different reasons. Some solicitors like to use jails to sweat pleas. We know that because even the current Chief Justice acknowledged that at oral arguments for a certain case, okay? Regarding control of the docket. Regardless, it happens, all right? Other times, they might have totally legitimate reasons, right? Yes, ma'am?
If bonds revoked, do you still have to wait 6 months after?
I would give it a cool down period. Right? Be smart, all right? Know your case, know your client. If bonds revoked, bonds revoked. It's not the same thing as a bench warrant, though, all right? They're kissing cousins, but they're definitely, separate entities, all right? People say, oh, he's got to sit in there and tell the thing. No, it isn't a bench warrant. Even then, I can still move to bench warrants. If his bond was revoked, let's figure out why, right? Before I go back in there and ask the court to reconsider that again. Again, I'm looking for material change of circumstances, right? Because I know that's what the judge is going to hear. Again, know your audience, okay?
My client's bond was revoked, and then I got his second case dismissed.
Sweet. Oh, let me guess, and that was the basis for revocation, right?
Yeah.
Material change of circumstances all day long. I love it. Yeah, bring it up. Judge, the only reason why he's still being held right here is for this other charge. That other charge does not exist at all on planet Earth. Why is he in here now? Get him out, right? Bring it, and make sure you have everything there. Shoot, you can even attach it as exhibits to your motion when you actually file your motion, right? Here's the dismissal sheets. Here's an all posture, whatever it is, right? Yeah, send it in there. Okay, good question. Okay, why? Because again, even for motions for revocation, they still have to show a prima facie case or that they do have reason for revocation, okay? Emergency bond revocation hearings. I really don't like these, but they're starting to happen more often than not, especially in certain counties. I'm sure you all are well aware, okay? How am I doing on time, Lawrence? We good? Oh, no, I'm over. Okay, sorry, I'll keep it quick. Again, they're going to have to show a prima facie danger, case, imminent danger to the community, or imminent danger to the defendant, or a flight by the defendant. Judge, he's on a plane right now heading to Bermuda. We got to get him off that plane. Whatever, okay? They can do this stuff. However, what? They got to have a bond hearing within 48 hours. Okay, fine. And at the time, it's an emergency, so they're not always going to be able to get notice to the bondsman, et cetera, or the defendant himself. However, even if they do have that hearing, once he is brought in, you're going to have another hearing afterwards if you really want to. If the hearing's conducted without his presence there, then yes, he can get a hearing itself to reconsider the revocation. Okay? Again, after filing and serving the motion to do so. All right? So, questions? Concerns? Stabs in the back? Anything, right? No, okay. Listen, I mean it when I say this. Holidays are upon us, and we're not the only people that have families, all right? There are clients, they're human beings, they're people. They have lives, they have families. You might not see them often, but nonetheless, help them get out. On top of that, it does help us help our own cases, all right? There's a reason why it's good to have your client out on bond, because they might be able to turn around and without us having to file, subpoenas or get HIPAA waivers to turn around and get other information for our client's case about something, it's easier for them to get it sometimes. I want that, all right? I have my investigator go with him, so it's turned over directly. The client says, yeah, give it to this guy. Boom, I got it. Custody's not a problem. Done and done, all right? It helps the defense to have your client out, and it also helps your client, okay? Studies have actually proven over time that people who are out on bond typically get a lower sentence if they are convicted than somebody who's actually been in jail. Fact. Think about that. And the people who are mostly sitting in jail are people who can't afford bond. Think about that. Right? The system is grinding on our people. We're the only ones standing up for them in that courtroom. So let's go out there and make sure we give it our absolute best effort to stand up for each and every human being that is incarcerated right now in pretrial incarceration and try our best to get them out on bond. Thank you.